Weeks, Contact 5 has requested hundreds of records trying to get answers about Epstein's work release.
And tonight, the state's top law enforcement agency is asking some of the same questions. Our investigator, Maris Badcock, found the sheriff's office policy has shifted and changed several times over the last 20 years.
Convicted sex offender Jeffrey Epstein's work release privileges have put the Palm Beach County Sheriff's Office at the center of controversy. Epstein was in jail from June 30th, 2008 to July 2009. He spent about 3 months locked up before work release kicked in, 12 hours a day, 6 days a week. As it turns out, Epstein qualified for the program based on the policy in place at the time. We showed that policy to criminal defense attorney Greg Lerman.
Under the 2007 policy, the Sheriff's Department had the ability, the discretion, to allow Mr. Epstein out on work release. That's not a question. But they should have used more common sense.
In 2007, the Palm Beach County Sheriff's Office rewrote its work release policy specifically to say that all inmates would be given equal access to the program unless they were a potential threat to the safety of themselves, staff, or other inmates, or to the security of the facility. Missing from that list is a threat to the community. That specific threat wouldn't be added to the policy until 2011, after Epstein was released. Epstein pleaded guilty to 2 prostitution crimes, one for soliciting a minor. Since 2000, prostitution crimes were on the list of ineligible offenses if you had 2 guilty pleas within 10 years. But in October 2003, according to PBSO records, the policy changed to 3 guilty pleas within 5 years. Had that old policy still been in place, Epstein would have been disqualified from the work release program. Also missing from the list of ineligible offenses in 2007, sex offenders. That means inmates like Epstein were allowed out in the public on work release despite their sex offender designation.
Common sense to me, as just a citizen, not just as a defense attorney, would say that if somebody's a sex offender, the Sheriff's Department should have rejected him for their program.
Convicted sex offenders were not added to the list of ineligible offenses until May 2011, after Epstein had been released. Lerman says, aside from a court order, Sheriff Rick Bradshaw has the ultimate say in who gets work release.
I deal with these issues all the time, constantly. Who can get on work release and who can get on house arrest. And the Sheriff's Department can reject anybody they want for any reason.
PBSO spokeswoman Terry Barbera told us last month Epstein qualified for work release because he wasn't a registered sex offender.
Absolutely ridiculous. He was designated a sex offender. Whether he registered or not shouldn't make any difference. He only didn't register because he was in your custody and wasn't supposed to be out. And he was out.
We asked Barbera for clarification and received this response in part. We have given you countless records and video verbiage to answer your questions. I ask you to please refer back to all the documents and video verbiage you have been given to answer any additional questions you have.
PBSO continues to deny our interview requests, citing an open criminal and internal investigation. Recently, our attorney sent a letter to PBSO asking the agency to turn over all records pertaining to the Epstein case, records that have been made public in the past. If you would like to read the specifics on the changing work release policies we've uncovered, you can go to WPTV.com. I'm Maris Badcock, WPTV News Channel 5.
Our Contact 5 investigators continue to stay on top of the developments in this case, and you can watch their investigations online at WPTV.com/Epstein.